a motion for bind over. I believe that the facts set up everything that's needed for count one, as it clearly shows that it's a controlled substance. It's cocaine. It was tested by the True Narc. In this case, Officer Hussein had testified about finding the narcotic residue inside the vehicle. Then the two larger bags, which were found at the hospital. In this matter, the defendant was the only one in the bathroom at the time in which these narcotics, or prior to these narcotics being discovered. He was informed not to flush the toilet, did so anyway, was also informed not to basically make sure that he could be visualized. In this case, he saw that he bladed himself towards the trash can, away from the view. There was fervent movements with his hands, and then all of a sudden there happened to be, while he washed his hands, there's two baggies of one bag of cocaine, one bag of crack. It just happened to be wet at the time in which, generally right after he washes his hands, Your Honor. So it's been tested and shown as far as count one is concerned. But when it comes to count two, Your Honor, I believe...
All right, folks, let's get straight to the point. This case is clear-cut. The evidence is solid. Lab-tested cocaine, bagged and traced back to the suspect. Officer Hussein spotted residue in the car, and it didn't stop there. At the hospital, two wet bags were found after the suspect tried to flush something in the bathroom, despite being told not to right after that. Officers found those baggies near the trash. Contents: cocaine and crack. Coincidence? Definitely not. The timeline matches perfectly. This guy was caught plain and simple.
Of narcotic trafficking in cells. It's our position, Your Honor, based on the fact that there was a scale there, multiple small baggies for, numerous small baggies for packaging, tear-offs, which are commonly used as packaging, two different types of narcotics placed in two different bags, both of which are above the normal use for personal use. In this matter, we have one at 14, I believe one at 30 grams, Your Honor. One of those, I believe, which would be the cocaine, this pure cocaine, Your Honor, 30 grams, that's over an ounce. He had over an ounce of cocaine and then approximately half an ounce of crack cocaine, Your Honor, with baggies, with the scale. Those are every single thing beyond our address book that one would need for distribution, Your Honor. So we do believe that there is more than enough probable cause to sustain the additional charge that the people had requested, which was...
Let's be clear, this wasn't personal use. The officer explained it plainly. Scales, baggies, and two types of drugs packaged separately. They found over 30 grams of cocaine and nearly half an ounce of crack, all ready to sell. This isn't small time. It's obvious he wasn't holding it for himself. The setup and the amounts both point straight to drug dealing. No question about it.
The intent to deliver, which would be a delivery of manufactured controlled substance less than 50 grams, would show that the total weight of this was 45 grams, Your Honor, just under that 50-gram threshold, and that it was all cocaine or a mixture that contains cocaine, Your Honor. So for those reasons, and of course we've already established venue, time, location, and identity. So, Your Honor, at this point, we do ask that the court bind over on the original count one and the added count two of delivery and manufacturing of a controlled substance less than 50 grams.
Thank you. The first element of this, of course, is that the defendant possessed controlled substance, in this case, the allegations of cocaine and crack cocaine. There was a pat down, and a full search before the hospital, before any of these allegations happened, by trained law enforcement officers. They know how to do the searches.
Here's where the defense makes its move. They're arguing that nothing illegal was actually found on him, not in his pockets, not on his clothes, not even in his system. The officers did a full pat down before he went to the hospital and came up with nothing. So now the defense is asking, if he didn't have anything on him, how did those drugs end up in the trash can? They're pushing the idea that the hospital bathroom was public. Anyone could have left those bags there. That's their argument, and they're holding firm on it.
Colarossi was in training, but also trained to do a search, obviously. Nothing was found on my client's person. Nothing in his system from the blood draw. No drugs, no alcohol. So really the possession comes down to these two bags that were found in the trash can in the hospital bathroom. A bathroom that is open to the public 24/7, doesn't require any special entry. Anyone could walk into that hospital and use that bathroom. I was curious how often they cleared the trash can, but the officer from the hospital didn't know. So obviously those bags could have been there for any amount of time. The officer from the hospital testified that my client had irregular hand movements.
But here's the catch: the drugs didn't just show up. Randomly, they were found right in that trash can, minutes after he spent an oddly long time at the sink. Hospital staff noticed how strange his behavior was. He wasn't just drying his hands, he looked like he was stalling, maybe trying to hide something. No one saw him physically dump the bags, but the timing? It's way too convenient. And those wet drug baggies? That's no accident. Everything about it looks suspicious, raising serious questions about what really happened.
In the day, all he said was, well, he was drying his hands for an irregular amount of time or something to that effect. I mean, that's, I just don't think there's a lot there to support probable cause, respectfully. And no one saw my client put anything in the trash can. And of course, Your Honor knows there's two types of possession, right? Actual and constructive. Presumably the people are arguing both, that he actually possessed these, but that nothing was found on his person. Constructive possession is, of course, and then there's case law, I think Mr. Danner is aware of. There's a Sixth Circuit case interpreting Michigan law, and then there's a Michigan Supreme Court case, and I have the citations, I'll mention them quickly, but basically proximity to contraband is not sufficient proof for possession, for constructive.
Now, the defense is playing smart. They're not arguing about the drugs being found, they're focusing on the law. In Michigan, just being close to drugs isn't enough to charge someone. The law requires proof of control or intent, not just proximity. They're backing this up with serious case law, like Parker v., Reno, and People v. Wolf, their point. There's no direct evidence linking him to those drugs. No fingerprints, no weapon, no video of him dropping anything. Without something solid tying him to that stash, the defense says the case falls apart. And honestly, that's a pretty strong legal angle.
To be something else connecting a defendant to the contraband, whether it's a weapon or a controlled substance. And I won't go through a lot, but I would just like to, for the record, say that I'm referring to a Sixth Circuit case, Parker v. Renico, 506 F3rd 444, interpreting Michigan law, decided October 17, 2007. And that case cites many cases, including a Michigan Supreme Court case, People v. Wolf, WLFE 440 MISH 508, decided in August 31st, 1992. Very briefly, what the Sixth Circuit says is, as with the federal rule, a person has constructive possession if there's proximity to the contraband, together with indicia of control. In other words, proximity alone never suffices. Cites the Michigan Supreme Court case. And
here's the twist: the defense is staying sharp. They're not denying the drugs were found. Instead, they're sticking to the legal rules. In Michigan, just being near illegal substances isn't enough to prove guilt. The law says there must be proof of control or intent, not just closeness. They're leaning on key cases like Parker v., Reno, and People v. Wolf to back that up, and honestly, they have a point. There's no direct link tying him to those drugs. No fingerprints, no video, nothing clear-cut. Without hard evidence, the defense argues this case could easily fall apart.
the ultimate question, according to the Michigan Supreme Court, is whether the evidence establishes a sufficient connection between the defendant and the contraband to support the inference that the defendant exercised dominion and control over the substance. That's beyond the mere proximity. So I respectfully assert that there is not probable cause on that first element for actual or constructive possession. The second element, defendant knew that he possessed a controlled substance. That would have to be inferred. There's no evidence of that. There's no statements or admissions. So that would have to be inferred from the first element. And, well, there is testimony of the weight. So that's the third element. So for all those reasons, well, I'll leave it at that. Thank you.
I really don't need rebuttal.
Please subscribe to support the channel. It's official now. The judge ruled that both charges possession and possession with intent to deliver. Going to circuit court, the defense tried, but it didn't work. The officer's testimony, the timing, and the drug amounts convinced the court even the defense's legal arguments weren't enough to stop the case from moving forward. The judge said there's enough evidence for trial. Now it's up to a jury to decide. This case is far from over.